Let's listen to Pavarotti.
Hello, welcome to The Revealing. I'm your host Pavarotti, here to discuss the Idaho 4 case. As a disclaimer, this channel is for entertainment purposes. These are my opinions. I'm not here to slander, so let's get started. I'm going to give you information and give you my opinion on the information I provide. Because we had some new motions filed, and they're kind of interesting. One of them answers the question that I posed on a video yesterday, and we'll get into that. And the other one is Bill Thompson he is digging deep to try to negate the motions to suppress and the motion for the Franks hearing. Really, the motion to suppress all the genetic genealogy and the DNA and the motions for the Franks hearing. Because they're two separate things, two separate issues, I assure you. And I'll show you again in this one how what I'm saying is true. When you get to the Franks motion, I promise you, in my humble opinion, it's about the lack of disclosure of a confidential informant. And they want that disclosure so they can prove confidential informants' non-reliability. That's what it's about. It's two separate things. And let's just get right into it. Okay, so this is the first one. This is the order from the court. And it says, amended order appointing special assistant attorneys general. The above matter having come before the court upon petition of the Latah County prosecuting attorney and good cause appearing, it is hereby ordered pursuant to Idaho Code that Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as special assistant attorneys general to assist in the prosecution of this case. So Jeff Nye, being the Deputy Attorney General, is staying. So who does that mean is leaving? Well, that would be Miss Beatty. Now, I have noticed in the hearings, Miss Beatty is the one who makes really strong arguments in front of the court. Jeff Nye, I have not really been impressed with his argumenting ability. He's not a very likable guy. Beatty was strong. So for whatever reason, Beatty is bowing out, and they're giving Jeff Nye the permission to select any attorney general's office, deputy attorney general that they want. They can select any special assistant attorney general that they want. Now, I had somebody come on there and say, "Oh well, the attorney general's office is the best of the best, and Jeff Nye is the chief." He's not. No, Jeff Nye is not the chief. Whatever it said, the chief officer. So what they're going to do is Beatty wants out, and they're going to try to bring in the strongest. I guarantee you, the strongest litigator, the strongest arguer that they possibly can. Because this thing is getting away from them, and this is proof of that right here. Now, to show you that Bill Thompson is grasping at straws on the Franks motion and all of the genetic information, instead of going into actual case law to try to defend their position, he's going into local rules of the 4th Judicial District. Look at this. Let's see. Okay, so this is a filed motion to strike the defendant's memorandum. Not the motion, but the memorandum in support of the motion to suppress the genetic information and the memorandum in support of the Franks hearing. So instead of going after the actual motions, he's moving to strike the memorandums that explain the motions. And you can see Latah County prosecuting attorney moves to strike defendant's memorandum in support of motion to suppress RE genetic information. There's one memorandum, okay? Memorandum in support of motion to suppress the genetic information. Completely different memorandum in support of a Franks hearing because they violate the local rules of the 4th Judicial District. Memoranda in support of non-dispositive motions, these going into just judicial district rules, must not exceed 15 pages. The defendant violated this rule when he filed a 37-page memorandum to support his motion to suppress the genetic information. 37 pages of information on the genetic information. That is the IgG. And completely different information, folks. A 33-page memorandum in support of his motion for a Franks hearing. This is different than the genetic information altogether. This is for non-disclosure of a confidential informant whose reliability could not be verified and was lied and left out of the supporting documents and the affidavits for the warrants that were issued. All right, so without seeking leave of this court, see LR 8.3 explaining limitation in excess of those set forth in Rule 8.1 requires prior leave of court. So what he's citing are these local district rules, LR 8.1 and LR 8.3. And a memorandum in support is not filed with this motion as the state believes page limitations qualify as a routine matter. Again, see LR 8.1 and LR 5.3. The state requests that the court decide this issue without a hearing. LR 5.3, LR 8.1, and LR 8.3. So instead of a memorandum in support not being filed with this motion, he's just requesting just off of procedural local rules, this thing, the most important thing they can file in this case on the defense be thrown out without a hearing. So let's take a look at these local 4th Judicial Rules, 8.1, 8.3, and we'll look at 5.0 because there is not a 5.3 unless they've updated it since I found their rules that were established in 2017. Okay, so we find these rules located in the local rules of the District Court Magistrate Division for the 4th Judicial District, effective February 1st, 2017. Even though they're no longer in the 4th Judicial District, now they're in the 2nd District, so I don't know if it still applies. But here's Rule 8.1. It says, to the extent a party relies on facts in the record in support of or in opposition to a motion, the party must specifically cite to the record affidavits or documentary evidence. The moving party may submit a reply brief not to exceed 15 pages as provided by the rules no later than 3 days before the hearing, unless otherwise ordered by the court or as required by the initials. So it's a little local 4th District rule that he's trying to get a Franks motion and the DNA suppression thrown out on without a hearing. I'll have to check and see. In fact, I'll do it right now. What is the 2nd Judicial District's rules on this? Okay, so the Idaho 2nd Judicial District, the page limit for a memorandum of points and authorities is 20 pages, not 15. Now that is still less than, 33 or 37. And the page limit for reply brief is 10 pages. The court may grant an exception to these page limits in unusual circumstances, but using small fonts or minimal spacing to comply with the limit is not acceptable. So the court may grant an exception to these page limits in unusual circumstances. I would say this is the most unusual circumstance anybody could possibly imagine. So I can't see the judge striking these motions without a hearing based on page limits. Now, he also cited 8.3, the lodging copies of motions and memoranda. If the parties file documents within 7 days of a scheduled hearing, the parties shall deliver courtesy copies to the court chambers. Now, is the defense following this procedure? Okay, here was the motion for the Franks hearing. And let's see here. The parties stipulate to the sealing of the proffer and exhibits. The stipulation is filed contemporaneously. The under seal proffer and exhibits are being provided, should be provided to opposing counsel. They're being provided to the opposing counsel and court staff via email on the date of this motion, and hand delivery to the court for in-person filing will occur no later than November 18th, 2024. So as long as they followed through with hand delivering that filing on November 8, 2024, I believe they followed Rule 8.3. So what are you talking about, Thompson? Now, he also mentioned Rule 5.3, which there isn't a 5.3, there's just a Rule 5, and that's appearance of counsel contested motions. In the absence of a stipulation, which he had a stipulation, or court order granting a continuance, if the moving party or his attorney fails to personally appear to present an adversary motion at the time set, the court may summarily deny the motion for failure to prosecute pursuant to Rule 41B, or may deem the motion withdrawn. If the moving party or his attorney appears to present the motion, and the opposing party or his attorney does not appear, and the motion has been properly and timely noticed for hearing with proof of due service thereof, the court may render its decision on the merits of the motion. So, once again, as long as the defense followed through with presenting the motion in person, which I'm sure they did, Thompson is grasping at straws. So, if these types of responses from Bill Thompson give me some stronger counsel, because mine are dissenting, and let's get these Franks motions and genetic motions to suppress, let's get them thrown out because of District 4 procedural rules. They had too much information in their memorandums, too many pages. Well, number one, you're not in Kansas anymore, Thompson. You're not in the 4th Judicial District. The venue's been changed to the 2nd Judicial District. Pretty sure that the order of the change of venue suggested that everything's moved to the 2nd Judicial District now, and the 2nd Judicial District rules apply. So when you file your motions, you better file them based on the rules of the 2nd Judicial District if you're going to file that, not the 4th. But also, read closely in there. I know the 4th Judicial District didn't have that extra statement that based on unusual circumstances, the judge may grant an exception. 2nd Judicial District clearly states that. If the Bryan Kohberger case is not the most unusual circumstances case that your court will ever see, I don't know what is. So in my humble opinion, those are, let me throw as much crap against the wall and maybe something will stick, moves by the prosecution I've ever seen. People always say that about the defense. Oh, they're throwing everything they can against it. Now they're doing their stuff in strategic mode, things they got to do. Prosecution, you're throwing stuff against the wall hoping it sticks. What you scared of, Santa? But please like and subscribe to the channel. Post your comments, thoughts, criticisms. Till next time, Pavarotti's out.